President Bola Tinubu has warned members of the Presidential Elections Tribunal that removing him as president could lead to a breakdown of law and order in Nigeria. Mr. Tinubu admitted his failure to score 25% of votes cast in Nigeria's capital, Abuja, but said it was insufficient to overturn his victory as declared by the Independent National Electoral Commission, INEC. Any other interpretation different from this will lead to absurdity, chaos, anarchy, and alteration of the very intention of the legislature. Mr. Tinubu's lawyer, led by Wole Olanipekun, said in their final defense statement to the court. The lawyers were specifically addressing a section of the Nigerian Constitution that said a presidential candidate must score 25% of votes in 2/3 of Nigeria's 36 states and the Federal Capital Territory, or Abuja. Public commentary has been rife about the intention of the clause after Mr. Tinubu won the highest number of votes in the three-way presidential race in February, but failed to score 25% in the FCT. Mr. Tinubu's team said courts have always been careful about giving extreme interpretation of the Constitution that could spark chaos. Our courts have always adopted the purposeful approach to the interpretation of our Constitution, as exemplified in a host of decisions, the team said. They also said Mr. Tinubu would still have won the election even if he didn't score anything in Abuja or one other state. Although this was not the argument of petitions, Atiku Abubakar of the People's Democratic Party and Peter Obi of Labour Party. Even if there was no election in one state, including the FCT, or even if the election of the states, including the FCT, are voided, the entire election cannot be voided or cancelled. In concluding our arguments on this issue, we urge the court to hold that any election where the electorate exercise their plebiscite, there is neither a royal ballot nor royal voter, and that residents of the FCT do not have any special voting right over residents of any other state of the Federation, in a manner similar to the concept of preferential shareholding in company law. We urge this court to resolve this issue against the petitioners and in favor of the respondent, the lawyers said. INEC had on March 1st declared Mr. Tinubu winner of the presidential election held on February 25th. The Electoral Office said Mr. Tinubu scored 8,794,726 votes to defeat Messrs. Abubakar and Obi, who polled 6,984,520 and 6,101,533 votes, respectively. In the respective petitions, Mr. Abubakar alleged widespread irregularities and cheating in the election, while Mr. Obi alleged similar grounds but went further to challenge Mr. Tinubu's eligibility for the election on the grounds that he had previously forfeited money to the United States after being slammed with allegations of drug trafficking and money laundering. Mr. Tinubu's lawyer denied the allegation in court, saying whatever payment Mr. Tinubu made to U.S. authorities was not in the form of a fine, as stated in the Nigerian Constitution. In any case, the case did not happen in Nigeria, the further argued. Mrs. Abubakar and Obi are expected to file their responses individually to the arguments mounted by Mr. Tinubu's lawyer in the coming weeks. after which the tribunal, a panel of justices of the Abuja Division of the Court Appeal, would finalize arguments and deliver a judgment. Notwithstanding the final judgment of the tribunal, the matter is widely expected to terminate at the Supreme Court, which would then have 60 days to deliver its ruling. Amidst the controversy surrounding the presidential election held on February 25, 2023, more clarity has emerged regarding the correct interpretation of the 25% of all votes cast in the Federal Capital Territory, Abuja. The clarity came from a Supreme Court ruling in a case involving Muhammadu Buhari of the then All Nigerian People's Party (ANPP) and Olusegun Obasanjo of the then People's Democratic Party (PDP) on Friday, July 15, 2005. In its ruling, the Apex Court had upheld that presidential candidate must win 25% of all votes cast in 24 states and the Federal Capital Territory, Abuja. One of the cruxes of the matter for determination in Buhari versus Obasanjo 2005 was Section 134, subsection 1 and 2 of the Constitution, which said, 1. A candidate for an election to the office of president shall be deemed to have been duly elected where there being only two candidates for the election. A. He has the majority of votes cast at the election, and B. He has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. 2. A candidate for an election to the office of president shall be deemed to have been duly elected where there being more than two candidates for the election. B. He has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. The trial of the petition, which lasted about 15 months, began before the Court of Appeal, Abdullahi PCA, Mahmood Mohammed JCA, as he then was in Sofo and Tabai CA, on the 25th day of September 2003, ended on the 20th day of December 2004. The court heard the 139 witnesses called by the first and second petitioners, first and second appellant, cross appellant, the 100 witnesses called by the first and second respondents, appellant, and the 116 witnesses called by the third and sixth to 268 correspondents, cross correspondents, being altogether 355 witnesses. In the leading judgment of the Court of Appeal delivered by Tabai JCA with Nsofo JCA dissenting, the court held as follows: I have considered the evidence in support of the allegation in each of the 14 states which elections were questioned, and in the exercises I have cancelled the election in Ogun State, some local government areas, wards and units. The question is the effect of this annulment on the election in the country. For the determinations of this question, I refer to the provisions of Section 134, subsection 2 of the 1999 Constitution of the Federal Republic of Nigeria. Section 134, subsection 2 of the Constitution provides a candidate for an election to the office of president shall be deemed to have been duly elected where there been more than two candidates for the election. A. He has the highest number of votes cast at the election, and B. He has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. This provision appears clear to me, where a candidate wins the highest number of votes cast in at least 2/3 of the 36 states in the Federation and the Federal Capital Territory, Abuja. He is deemed to be elected. More news later.